My name is Richard August, and I'll be your host. Our guest is Frank Soccoccio, the president of the Rhode Island Second Amendment Coalition and a practicing attorney in Johnston. Welcome to State of the State.
Thank you for having me.
Now, amid much fanfare and wearing a red Moms Demand Action t-shirt, Governor Dan McKee signed into law 3 common-sense gun control bills enacted in the wake of the tragic school shooting in Texas. And in addition, the United States Supreme Court handed down a major 6-3 ruling in New York State Rifle and Pistol Association versus Bruin that favors the Second Amendment. Let's discuss both. The first bill is a ban on openly carrying a shotgun or rifle in public except when hunting. Mr. Soccoccio, did the Second Amendment community oppose this measure?
Yes, we did.
On what basis?
The basis is individuals have a right to protect themselves, whether it's a pistol, a rifle, shotgun. To sit there and say to somebody, you take one step off your property with a rifle or shotgun, you're committing a felony, has nothing to do with self-protection on that. It's just another attempt on them to restrict individuals' right to keep and bear arms and to self-defense.
Now, did the ban apply only to firearms that were loaded, or was it across the board? Even if the gun was unloaded,
I believe it's loaded.
Okay. Okay, next is raising the age to buy any firearm from 18 to 21. Previously, an 18-year-old could legally purchase a long gun. This is probably in reaction to the recent shootings in Texas and Buffalo, New York, in which the perpetrators were under 21. Now, Mr. Soccoccio, isn't this a common sense thing to do, is to raise the age to 21?
No, it's not.
Why do you say that?
An individual who reaches the age of majority is allowed to vote, can go to war, can become a police officer. Why is there an absolute ban when they turn 18 and to move it up to 21? It's just, it doesn't make sense to me on that. If they were worried about people not getting firearms that shouldn't have them, such as mental illness or threats, then there are other ways that they could have done that instead of an absolute ban on that. You suppose you have an individual who has been on his own, or she's been on her own since 16 or 17. When they reach the age of majority and they're on their own, they can't protect themselves, it's not right.
Okay, and finally, the gun control lobby got one of its highest priority bills passed. It bans the possession of any detachable ammunition feeding device, otherwise known as a high-capacity magazine that holds more than 10 rounds. This bill passed the House and the Senate on highly technical grounds. Will you explain what happened? I understand that in the House Judiciary Committee, there was some technicality that got it to the floor, and in the Senate side, the Judiciary Committee was actually tied, which means the bill would have died there. So could you explain to our audience how these bills made it to the floor for a vote?
Yes. What happened is the bill has to go through House Judiciary and then Senate Judiciary. They have to go to the floor and be voted on. In the Senate, the bill was presented to the Senate Judiciary, and it was a tie, 6-6. So the bill, according to the rules, should have been dead for the entire year. What they did was they called into session the senators, and they took the House bill and voted that around the rules to put it onto the floor to vote that bill in. I believe it's a violation of the rules, but the bill passed that way. It should not have passed. If a bill dies in committee, it's supposed to be dead for the year.
The paper, I think the newspaper said that there was actually like a procedure that was 60 years old, had never been used. Did you hear, or are you aware of that?
I don't know, but I don't know.
Okay.
Don't have information on that.
On the House side, there was also something unusual that happened. I understand that was in danger of also facing a tie vote. Are you aware of how that got out to the floor?
I'm not aware of that.
It was the House Speaker and the Majority Leader actually went down and cast their ballots as ex officio.
Yes, they can go in as ex officio. If they're head of the committees, they can go in and vote. So if it was going to be tie when he came in, yes, they could have voted that way.
Now, not every state that has a similar ban places the limit at 10. For example, Colorado says it's 15. New York says it's 7. Vermont, which is a constitutional carry state, places the limit at 10 for rifles and 15 for pistols. Mr. Soccoccio, does anyone know when or where 10 became the magic number for magazines Is an 11-round magazine 10% more lethal than a 10-round? What is this based on?
It's an arbitrary number. That's all it is. There's no way to say that statistically 10's better, 15's better, 30's better. It's just an arbitrary number they came up with to make themselves feel better, saying we're limiting the amount of ammunition someone can carry.
It's kind of worth noting, I think, that they call it the Protecting Our Kids Act that passed the House of Representatives, and Speaker Pelosi was very proud of it. That act actually sets the limit at 15, not 10. It's kind of interesting to see there's not a unanimous opinion that 10 is safe and 11 is not. So, 7 other states, in addition to the 3 I named, have some restrictions on high-capacity magazines. However, neighboring Connecticut, Massachusetts allowed those who already owned 1 or more of these magazines to keep them. And our House of Representatives flat out refused to consider an amendment. Why? Why? I mean, how? They keep pointing to Connecticut and Massachusetts as models of gun control, and yet those 2 states allowed people to keep them.
I think it was just a PR issue to go on that. Peter Nerone came out and said that if you grandfathered them in, that it would be very difficult, if not impossible, to enforce them, even though other states have it and they enforce it. So I think it was just a PR stunt on their part.
And so he never explained how, he never looked to the other states to see exactly how they would enforce it if there was a grandfather. He just, I know he sent a letter to Smith Hill during the hearing stating that, right?
That is correct, yes.
Okay. Now, I heard the Attorney General on a local radio talk show that he used it as an example. Police served a warrant for a hit-and-run accident and found in the apartment a 50-round drum magazine and a 30-round standard magazine in the apartment. There were no guns. But Attorney General Rona said he needed this law so he could have something to charge the guy with, because he must have had a reason for having the magazine. Should we be passing laws so the Attorney General has something to charge people with?
No.
I spoke to a firearms dealer just before the bill passed the House, and I asked him if his distributors would take back all of the high-capacity magazines he had in inventory, and he replied no. I asked him, well, what about the high-capacity magazines that came standard with the guns that you have in inventory? And again, he replied in the negative, and he added, there are no 10-round magazines available for some firearms. Now, dealers and citizens under the law that stands have 180 days to get rid of all high-capacity magazines in their possession. Doesn't this amount to uncompensated taking of private property by the government?
It is. It's an unlawful taking, and it should be declared to be unconstitutional on that. You can't take people's property without just compensation on that.
Now, when this bill first was introduced several years ago, I met with House Judiciary Chairman Representative Bob Craven, and I asked him about that, and he said the 180-day disposal period takes care of that challenge. Do you agree with that, or do you even know, is there some precedent that he was referring to?
I don't know what precedent he was thinking about on that, but 180 days to get rid of something that you lawfully have, especially since you can't sell it to anybody in the state of Rhode Island, can't give it back to the manufacturer, nobody's going to want it, the dealers are not going to take the liability of having a used magazine in there for obvious reasons, so it still comes down to a taking.
And so the law says, okay, even though you own this legally prior to the passage of this law, now you must dispose of it. And there's no real way to, I guess the only thing you have in that 6-month period, you could sell it in a state where they're not prohibited, I suppose. That's the only avenue you have. And the only avenue a dealer would have, too.
Correct.
Okay. The Attorney General said that he expected that a court challenge would be filed. And indeed, a suit has been filed in the federal district court. Are you familiar with this filing? And you tell us what the constitutional grounds it's based on?
I am familiar with the filing. I actually sat with the firm that's doing this. We spent a few hours going over the complaint. I put my input onto that, and it was filed. The constitutional challenges are, well, constitutional challenge initially was it was a unconstitutional taking on that. But since the Bruin decision, that has changed. Now it's actually the restriction itself should be deemed to be unconstitutional.
So that is are there more than one grounds for that challenge?
Those are the basics ones on that, basic challenges on that, and I believe those should prevail. There's also a request for an injunction in that. So when they go into federal court, they're going to ask the federal court judge to enjoin the state of Rhode Island from enforcing or criminalizing the possession of any magazine over 10 rounds. So I'm hopeful, and I'm pretty sure that that's going to prevail on an injunction.
So the injunction would say that the 180-day clock is not running and it actually is suspended until the court hands down a ruling?
The court could actually enjoin it temporarily, or could enjoin it for the length of the proceedings. It's depending on how the judge rules on that.
Okay. And that is federal district court, I guess.
Yeah, the First Circuit.
Okay, First Circuit. So it would go to the First Circuit Court of Appeals if there was an appeal necessary?
Correct.
Okay. Have any of the other circuits ruled on this issue that you're aware of?
There are magazine limitation bans, and there are lawsuits in several different jurisdictions, and there's actually right now there's a split in the circuits. Some circuits say that it is constitutional to limit the magazine capacity. Other circuits say it's not. So when you have a split in the circuit, then it's ripe for a United States Supreme Court case.
Okay.
But I believe the decision in Brewer is going to eliminate that, and I don't think the magazine limitation is going to be found to be constitutional.
So let's move on to that decision. The United States Supreme Court made headlines last week, and the court ruled 6-3 that the New York law requiring a showing of need to carry a concealed weapon was unconstitutional, and the Second Amendment extended to an individual's right to carry a firearm in public. The landmark Heller decision in 2008, which was a 5-4 decision, said the right to own and possess a firearm was an individual right, not a militia right, and applied to having a gun in one's home for defense. Now, Rhode Island has a 2-tier process for obtaining a concealed carry permit, or CCW. One can go to a municipal police department who shall issue upon showing of a need, or the Attorney General who may issue upon showing a need. Mr. Soccoccio, you are quoted saying that AG Nerona's office uses, quote, super secret, untold rules when issuing a permit. Can you explain that comment?
Yes. So what happens is you can go onto the Attorney General's website and you can print out their concealed carry weapons permit, and they have a list of several factors which they consider when they're looking to see if you have a demonstrated need to carry a firearm. I've done numerous concealed carry weapons permit denial appeals, and I have 7 cases pending right now before the Rhode Island Supreme Court on this. When you go in and you ask Peter Nerona's BCI division, what are the factors that you determine whether somebody has a demonstrated need or not? And they say, we're the ones that decide. Well, what are the factors? Can't tell you. What are the standards and guidelines? We decide. So that's one of the bases for that. I'm like, okay, so you actually grant people an appeal on a denial of a concealed carry weapons permit application. You grant them an appeal to come in and say, what else would you like to supplement or add to give us so that we can, maybe approve your permit? And I've asked the question several times. How is somebody going to supplement their application or give you additional information when you don't tell me what the standards and guidelines are? So what do we have? Double secret probation? Like, what are we doing here? So there are no established standards and guidelines. They decide. So I'm appealing that. I have 7 cases pending before the Rhode Island Supreme Court. They're going to be consolidated, and I intend on putting the chief of the BCI division on the stand under oath, and I will say, you tell the Supreme Court, what are your standards and guidelines? Because if the Supreme Court can't judge whether you granted or denied based on those standards, you unconstitutionally denied somebody their permit. So they do have double secret rules.
Well, I think it was Attorney David Strackman, who you might know, who successfully argued a case in the state Supreme Court. He was on this program, and your comment is very interesting because he said at the time he argued the case, I think it was Mosby perhaps, that the chief of the BCI said the same thing. And when he was asked on the stand, what stand did you use, he pointed to his head and said, they're up here. And he said the judges were shocked when he said that. So things haven't changed much in the Attorney General's office, it seems, even though the court also said, I believe the Supreme Court said, we don't want to get involved in hearing all these appeals. So basically, in that situation, I think it was City of East Providence was
Correct.
denying, and they said, you have to tell people why you're denying it. You just can't send them a letter saying you're denied.
Correct. And the reason they have to tell them why they're being denied, and you have to put it in writing, is in the event that there is appeal granted or writ of certiorari is granted to the Supreme Court, the justices need to look over and say, what was your basis? What was your mindset? What were you thinking when you denied this person? So if a police chief says, well, it was all up here, judge is going to say, great, overturned. Because there's no way to judge whether that standard was met or not.
Now, the gun control lobby has been pushing for years for a bill that would make the Attorney General the sole issuing authority. In other words, there wouldn't be a two-tier approach. And I assume the Second Amendment Coalition opposes this idea.
It actually would violate the mandate of the Rhode Island Supreme Court. In one of the Supreme Court decisions, when they looked to see the constitutionality of our permitting system, the Rhode Island Supreme Court clearly stated in its decision that because Rhode Island has a two-tier system, a may issue and a shall issue, that the two-tier system is constitutional. So what happens when you take one of the tiers off? Is it unconstitutional,
Right,
correct?
Obviously, sure.
So
in Rhode Island, let me be clear. If you have a municipal permit, in other words, you go, I don't know, any town or city, you are issued a permit by the chief of police, and is that good all over the state?
yes,
If you go to the Attorney General, I would assume that his permit, if you get one, would be good all over the state as well.
correct, same.
So the result would be the same, although in the case of the Attorney General, it appears there is discretion because it's a may issue, whereas at the municipal level, they shall issue, which is less discretionary.
Correct, but there are different standards also with the different licenses. If you had a license from a city and town, you could walk into a gun store with a gun, clearly concealed, loaded, and you could go into and say, I want that one in the case. With a city or town permit, you can go in and you can actually pick up the firearm. With the Attorney General's permit, there's a 7-day waiting period under the exact same circumstances. Under the Attorney General's permit also, if you have a job which requires you to carry openly, say like Pinkerton Security, Securitas, or an armored car, whatever the company is, and they require you to be in uniform and open carry, you can't do that with a town permit. You need an Attorney General permit.
Oh, I see.
The language of the statute, 1147, says concealable. 1147-18 says can carry a firearm. So that allows for an open carry in uniform for your job.
Does a person have to be a resident of the city or town in which they reside to go to that town or city?
Normally they do. If you have a business in the town, you reside in the town, they'd like you to go to that police department with your application. But in the event that you have an out-of-state permit, you can go to any town you want. There's no longer a residency requirement if you have an out-of-state permit.
Okay. Attorney, your colleague that I referred to, Attorney David Strackman, was quoted as saying, some towns simply refuse to issue or even accept an application. Will the ruling in this Supreme Court open the door to those towns that will say you must accept this application now because state law says you should?
They don't have discretion under the statute to not take an application. They are required under that. When somebody presents an application, they have to process it. There's nothing in the statute that says, oh no, we're not taking applications. They have to.
But in your experience as an attorney, are there cities and towns that simply say they're not going to accept it if you walk in? And
Well, they take it, and then it sits there for a year or more, and then they'll deny you.
Oh, okay. Now, writing for the Associated Press, Jessica Gresco leads her article with this story, and I'm going to quote, "The Supreme Court said Thursday that Americans have a right to carry firearms in public," end quote. Is that what the court said? Can Americans now strap on a handgun and then go walking around in a town or city?
What the Supreme Court basically stated was, you have a right to utilize a firearm for yourself for personal protection in the home and outside the home. They also went on to say that states may have a permitting process which allows for the permitting of an individual to carry a firearm in public. But the restrictions have to be reasonable restrictions that are based in historical precedent. So they can't have restrictions like New York, which make it so difficult that no one other than, the police department's buddies can get one, or an ex-police officer.
Yeah, I recall, and you may recall, that there was a radio host out of New York who acknowledged being a drug addict and a recovering alcoholic, who bragged about the fact that he had a concealed carry permit in New York City, which you would think on the surface of it would be a denial, a basis for a denial, but he was quite proud of the fact that he had a carry permit in New York City. I guess that happened. They say a lot of entertainers and sports figures, for example, celebrities, are able to get a permit where an average citizen, they just don't even want to hear it.
Yeah. We're pretty close on average to New York, because currently right now there's only about 4,000 people in the state of Rhode Island that actually have permits. That's combined with the cities and towns and the Attorney General's office. So figure it this way, about 1.1 million people in Rhode Island, 4,000 people have permits. That's less than 0.4% of the population actually has a permit to carry. Really kind of low, don't you think?
I think most of us hearing that statement would be shocked, because the impression is that there's just, well, especially when they passed the so-called Safe Schools Act, the impression they gave was that the hallways were being stalked by just a whole horde of gun-carrying people with concealed carry permits. I mean,
less than 0.5% of Rhode Island's population can carry a firearm.
And they have to go through, certainly, it is just a case of walk in and I want one. You have to go through a certain process.
Yeah. There's usually a 3-month delay. You have to go through it. There's a lot of process you have to go through. You have to prove that you are a responsible person, you're proficient with a firearm, clean background. There's a lot to get that. And right now, well, the last couple of years, when Moroner's been in place, his BCI department is denying people over and over and over again. People that have had a permit from the AG's office continuously, 20, 30 years, denied. And that's why I have cases in the Supreme Court.
Well, this will be a very interesting thing, and I want to also quote New York Governor Kathy Hochul, which you may have heard. She said the decision is painful to New Yorkers in light of the mass shooting in Buffalo. Well, it seems to me New York State has a ban on assault weapons, a ban on magazines holding more than 7 rounds. They did have at that time the Sullivan Act, which was pretty restrictive in terms of concealed carry. But these are the things that are supposed to prevent mass shootings that are in place in New York, and it certainly didn't stop what happened in Buffalo.
No, it didn't. It didn't happen at all. But I will point you to the what happened recently in Texas, where a person went into a church, and he went in there with the intent of shooting as many people as possible. There was a couple of concealed carry weapons permit holders. One of them ended up taking them out before he could shoot more people in the church. There are examples all the time of people that are lawfully carrying firearms which save other people's lives.
I think it's safe to say there are also a lot of cases that don't get reported because the person with a concealed carry permit displays the fact that they're carrying, and the bad guys run away, and that never gets reported anywhere.
Correct. Just brandishing a firearm a lot of times will stop the aggression, and these criminals don't want to get into a firefight. They're looking for an unarmed, easy target.
Now, in his retiring Supreme Court Justice, Breyer began his dissent with a recitation of the number of mass shootings. Now, it seems to me that when a judge prefaces his opinion with a list of current problems, he or she is not ruling based on the Constitution or the law. He's going to legislate from the bench. Am I being too broad when I say that?
No, you're not being too broad, but in the decision, the actual decision of the case, they actually did dispel that pretty quickly by saying other justices are going to talk about mass shootings, they're going to talk about this statistic and that statistic and this other statistic, and they said with the new ruling we put down, none of that's relevant. What it really boils down to is you have a right to protect yourself and your loved ones in your home and outside of that. Looking at statistics for criminals doesn't affect your right to protect yourself. The Supreme Court was clear in putting the Second Amendment back to where it should be. The right to keep and bear arms shall not be infringed.
I think in that regard, in conclusion, I think Justice Thomas, who wrote the majority opinion, of course, summarized his ruling in these principles, and I'll quote from it, and you can comment on them. He wrote, "We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense," end quote. Fair summation?
Fantastic.
Now, having said that, the vice chairman of the Rhode Island Coalition Against Gun Violence, Willis Peter Bilderback, called the ruling, quote, "extremely dangerous," and said, quoting again, "No court decision is going to stop the coalition from keeping Rhode Islanders safe," end quote. Seems to me that the gun control lobby bases their arguments on public safety trumps the constitutional rights, and they speak from the moral high ground. Is that a fair depiction?
Yes, they're hiding behind some of these statistics and some of these other things that they're putting forward to simply try to get as many firearms away from people, law-abiding citizens especially. They never go after the criminals. They never go after fortifying schools. Their main intent on that is just to take away your firearms based on let's keep people safe, and it doesn't work.
I think it was on Go Local Prov, just before we came on the air, I was looking at something that was written, and they talked about that their second jewel in the crown of the gun control lobby is, obviously, you know, is banning so-called assault weapons or weapons of war, whatever you want to call them. And they said that it looked like that had a chance of passage, but that the leadership in the Senate and the House didn't go along with it. But they never really were clear as to what. Do you know of any backroom maneuvering that took place that prevented the assault weapons ban from coming forward?
No. I do know that there was talk that it was an election year, and that would have been devastating to the Democrats if they put that out, specifically since the National Democratic Party said stay away from gun control this year. As far as backroom deals, I have no idea.
If this, obviously the Supreme Court ruling is going to stand, depending on the outcome of the suit in Rhode Island, do you think that will probably end some of this push for more gun control legislation?
Yes, because one of the things that's in the United States Supreme Court case is it switched the burden of proof now. Now, if there's a challenge to a Second Amendment restriction, the burden is on the government to show that it has historical precedent back when the Constitution was drafted and then ratified in 1791. Before, the burden was on the individual challenging it to show not only was it restrictive, but that the legitimate state interest should not have been on a balancing test. It should have been weighed against that. Well, so it's fantastic.
We are out of time. I want to thank Attorney Frank Soccoccio for being our guest. And I hope that in the near future we can have someone representing the gun control side of this argument on this program. And please stay tuned and watch for that. And we want to thank you for watching State of the State.